All right, so we're going to be talking today about what you need to know about purchasing workers' compensation insurance. First thing you want to know is it's really more like a beauty contest or a competition. You want to be making sure that you put your best foot forward.
In addition to giving your estimated payroll broken down by classification, your federal employer ID number, and details about your operation and ownership,
you're going to want to make sure your companies know, you have a great safety program. You have awesome human resources. You have supervisor and management accountability. These are all stuff Don Dressler and CalWorks Safety help you develop and perfect. The other aspect is if you do have claims, the insurance company underwriters are going to want to know what you've done to help prevent future claims from occurring. You need to develop a good story there to tell them, and it needs to be accurate. And the final thing is you need to be willing to work with their safety consultants, because they're going to send out their own safety consultants. The primary mission for their safety consultants is to develop information for the insurance company, and the secondary mission is to help you. So they're going to want to know that you're willing to cooperate, and that's going to go a long way to have them look at you favorably.
when you're getting quotes for workers' comp, you want to be sure you're with a very financially stable company. You can go online to AM Best, which is a firm that rates insurance companies based on their financial stability, and be sure whoever you go with is A-rated. The exception to this is the state fund in California, who does not have a rating, but is partially run and operated by the state government.
Another important aspect to an insurance company is you want to make sure they're going to be handling your claims in an aggressive fashion. They're on the lookout for fraud. They're going to be jumping in quick on those fraud claims, and they're working on all of your open claims to bring them to a close as quickly as possible. Statistically, the longer a claim stays in an open status, the dollar amount tends to climb, and then the effect on your experience modification goes up, and therefore your premiums go up. And so this is what you don't want to have happen.
You also want a very good safety program, consultants that will come out and look at your operation and give you recommendations on what to do to prevent losses.
So some of the characteristics you're going to want to see in your insurance agent or a broker are, first and foremost, you're going to want to have them be responsive. If you call them, you want to call back. You send them an email, you want an email back. You want to develop a nice, solid working relationship with your agent and broker. Knowledge and experience of the workers' compensation system is key. You want to have them put you in a position where you're getting the most for your premium dollar. They should have established relationships with the workers' compensation insurance company underwriters, where if they need to get a favor done, you can get it done because they're in good graces with the insurance companies. And finally, you want to make sure they have a stable of insurance companies that are all A-rated, competitive insurance companies that they can go out and shop the marketplace for you and come in and have them compete against each other to give you the best product available.
You also want an agent that will help you resolve audit disputes and get involved on your behalf with the insurance carrier. You want one that will attend safety meetings if you need them and add value. A lot of times safety people get off the beaten track and actually spend a lot of time at your facility that might be unnecessary, but a good agent can keep them back on track. You want someone that's going to help manage open claims, even claims that might have happened before you were with that broker. We frequently go back in time and pick up new clients and help them with older claims and getting them closed. Mm-hmm. And you want to get your quote well ahead of time, nothing at the last minute, no surprises. So you have time to make a good decision.
Now, what are some pitfalls that you need to watch out for? Well, one of the pitfalls we find is audits. When you start the policy, you provide an estimate. And then just like taxes, at the end of the year, you need to true up to what actually happened. So if you've had a banner year and you have a whole bunch more payroll, you could be surprised with a bill you weren't expecting. In addition to that, the auditor sometimes will come in, ask a bunch of questions, perhaps take some people that are in your clerical class code and throw them into manufacturing erroneously, maybe being a little overzealous in their job. And this is where you need to put the audit in dispute and provide job descriptions and get things back to where they were to begin with.
Ownership is very important in workers' comp. The insurance company will want to know the exact ownership of your company and who the officers or members are. And if you own 10% or more of the company and you're an officer, you will be able to exclude yourself, which happens frequently in companies. The exception to that is if part of your company is owned by a trust, an LLC, or another S or C corp, or if you're an ESOP, then no one can be excluded.
Out-of-state employees. A lot of times we'll find that California employer will hire salespeople, Arizona, Nevada, or any other state, and assume that the California workers' compensation covers them for any injury. And that's not true. You have to either buy a separate policy or turn your policy into a multi-state policy. So that's one of the things we always ask our clients is, do they have any out-of-state employees? And if so, where? So we can arrange for coverage. And we can do that in every state except 4, which are Nevada, well, formerly Nevada, not anymore, North Dakota, Ohio, Wyoming, and Washington, where you have to go to their self-run state fund workers' compensation pool.
You also want to be sure your experience modification is correct and it's included in your renewal premium. You want to be sure that quotes are based on the same payroll figures. Everyone's using the same payroll figures and that the mod is applied to the quote. Don't just look at the bottom line price, because you want to be sure that payroll and XMod is the same with every quote. And you also want to be sure if you have a company that requires DMV filings, that the insurance company knows about that, is able to do it for you, and if there's an additional price involved.
Sometimes landlords and customers require you to add waiver of subrogation clause to your workers' compensation policy. This can increase the premium up to 2% of the annual premium. So you have to kind of watch out for that. And if you're in a circumstance which you think is going to require this, you can contact your agent and your agent can price this out for you so you know what the costs are before you actually sign the agreement. And in the off chance that you might have someone in the state of New York, the state of New York does require you to provide disability policies, and you can purchase that directly through the state for all your employees working and living in the state of New York.
And that concludes our part of the program. We'll be around for questions at the end.
Great. Thank you so much, guys.
And I need to stop sharing. So here we go.
Let's see. Okay, so up next we have Yvette Banky. Yvette has been an attorney since 1989 with a practice emphasis in workers' compensation defense. Please welcome Yvette. And let me go ahead and share this for you.
Thank you. Yeah. Jake, you have the clicker, right?
Yep.
Okay. I've been asked to speak on how managing litigated workers' compensation claims. I have 5 tips for you today. The first is, don't take the litigation of a workers' compensation claim personally. Try to remain emotionally neutral. Whether the claim becomes litigated after it's been accepted, or whether the litigation process is your first notice of a claim, try to remain neutral. Your role as an employer is to convey information to the insurance company and to the participants in that process to effectively and cost effectively and timely resolve the claim. It's hard to do. It oftentimes when a case becomes litigated, it feels personal. You treated the employee correctly, you provided the medical treatment, you provided modified duties, so on and so forth. And it hurts oftentimes, but try to remain neutral. That's the first tip, oftentimes the hardest. The second tip that I have for you is to communicate. There's three main folks that you're going to want to communicate with when a case becomes litigated. First, the claim professional. Oftentimes, frequently, particularly at present, that's difficult to do. When a case becomes litigated, the claims professional assigned to the matter will send out a packet of information, and included somewhere in there is contact information. Keep in mind that the claim professional assigned to a particular matter can change throughout the course of the case, so try to keep up with that. If they do not initiate a personal contact with you, either via email or telephone, reach out to them, say, hey, I'm the employer representative. What's going on with this claim? What do you need from us? What information are you missing? Can I tell you about what really happened? That kind of open communication from the claim inception oftentimes will get that claim on a good solid footing for defense. It also can take care of any disputed facts can be addressed early on in the process. So reach out to the claim professional. And if they're not responsive, enlist the help of your broker to facilitate establishing that relationship. The second line of communication you want to open up on a particular claim is the legal professional for the insurance company that is assigned the matter. I am finding more and more frequently that the carriers are reluctant to assign legal counsel to the handling of a claim. I'm not sure that that is, in the long run, cost effective, but I understand why they are doing it. Once a legal professional is assigned, you want to reach out to that legal professional, usually an attorney, can be a hearing representative who's trained in workers' compensation matters and essentially authorized to appear before the Workers' Compensation Appeals Board. Whoever that might be, reach out to them, raise your hand, say, I'm the employer, I'm here to provide you with information. What's your litigation plan? Do you plan on taking the deposition of the injured worker? Do you need information from us? Can we clarify anything? Can we provide the names and contact information for witnesses, so on and so forth? The third line of communication is with the injured worker, the employee. Remain neutral about the case with them, but if they're still working for you, make sure that you continue to treat them in a respected manner, provide them with time off to attend medical appointments, work with them on modified duties, ask them how they're doing. If they're no longer with you and they've, they're either maybe terminated for cause or they're not happy with you in any way, if there's a situation for example, perhaps picking up a vacation check or whatever, greet them cordially, treat them personally. Don't get into the specifics of the claim, but as appropriate, keep that line of communication open as well. The third tip that I have to give for you is to attend workers' compensation proceedings. The two primary proceedings that I recommend an employer participating in is the deposition of an injured worker. In the workers' compensation world, that's known as an applicant, or hearings of various sorts. I've welcomed the participation of an employer representative at a deposition. I liked my employer sitting right next to me. I liked to meet them. I asked them about their business. I asked them how the work was done. How was this employee? What's not in the personnel record? Who did this person get along with? Who did they not get along with? Did they find this were they surprised by the litigation? Does it feel like it's a payback type of a situation? Whatever the circumstances are, I found the employer's input at depositions, I welcomed it. I had more than one case because the employer was sitting next to me. A fact was developed that turned the case around. Also, if the injured worker's testimony is truthful, the employer can say, yeah, that's what happened. That's exactly what happened. And then the attorney handling the matter for you can act accordingly. It can be a supervisor, it can be an HR person, but it should be someone who is at least familiar with the injured worker. I invite that. Oftentimes it's not welcomed by the attorney, but I strongly suggest that you pretty much insist on attending depositions. Under the statute, you are permitted to be present. An employer representative is entitled to be present throughout the entire deposition proceeding. And if you get any kickback on that, we can provide you with the statutory references to that. The second area, and I strongly encourage every employer to attend some sort of a hearing at the Workers' Compensation Appeals Board. Because of the pandemic, the boards have been closed for all proceedings for the last couple of years. They're just now starting to open up. I actually have my first in-person hearing in 2 years on Tuesday. So check with the handling legal professional as to making that available, but it's eye-opening. Just sitting in the back of a courtroom and listening to the parties, how they communicate as it relates to a claim or what the judges say can be an eye-opening experience. Then it gives you some awareness of the procedures and the practices, and oftentimes what the legal professional or the claim professional that's handling that claim for you is up against. Keep in mind, workers' compensation litigation process favors the injured worker. So attending a hearing, attending a deposition can keep you in the loop and make you aware. Also, your input is extremely valuable. The fourth point I have is respond to requests for information from all sorts of people. You're going to get requests for information. Respond to those requests in a timely fashion. I don't know what was up with September and October, but we had a number of subpoenas that were just wonky. I don't know what was going on with the sun, the moon, and the stars. And so you'll see it on the PowerPoint presentation. I encourage you to get a copy of it because it sets forth some issues that we did have. One, the subpoena most often will come from the injured worker's attorney, and it will come through a copy service. Copycat is one frequently used, MedLegal is one frequently used, and you'll get 6 or 7 pages of legal paperwork and your eyes will glaze over and roll in the back of your head and go, what the heck are they asking for if you've not had to deal with them in the past? The first and foremost is respond timely. Look on the documentation for when the due date to respond is, and keep that in mind. If for some reason you're not going to be able to provide or respond to the subpoena within that time, there's usually a contact information. You can call them up and ask for an extension. Subpoena is a discovery device in California workers' compensation. It's generally considered to be informal. The judges at the board don't like to deal with discovery issues concerning subpoenas. So informal resolution of any issues that arise is most important. That doesn't mean you're going to turn over everything. It just means that you have some flexibility, but you also have to work with the other side. If you're not familiar with responding to subpoena, I strongly encourage that you speak with a claim professional or the legal professional assigned to the claim before you respond. You can also seek counsel from a staff member at CalWorks Safety. Kayla and myself particularly address these issues, and we can take a look at the subpoena and say, you know, this is just way off base, and no, we're not going to provide the sun, the moon, the stars for you, but we can work with the other side in the copy service to say, yeah, this is what we will provide. If you do respond to the subpoena, keep a copy of anything you provide, and I strongly suggest that you make a list of what you provide for yourself and also include it in the materials. That way, at a later date, there's a question as to whether or not you provided a document, it's listed. You will also get a request for information from the claim professional generally when the claim is set up within a few days. That introductory material asks for basic information. They'll want a wage statement Generally, it's a computer run, will be satisfactory. They oftentimes it is accompanied by a questionnaire. Is the person expected to get a raise? Were there performance issues? Do you have any reason to dispute the injury? So on and so forth. If something requires more details, good opportunity to contact the claim professional and give that information in a verbal fashion in a little bit more detail. So the request for information, job description, payroll information, facts of the injury are most commonly requested by the claims professional. Any questions about that, again, you can seek counsel from CalWorks Safety. So whether the request for information comes from the claim professional informally, from the legal professional assigned to the claim informally, or via subpoena, timely respond to it, accurately respond to it, keep documentation that you've responded to it, in what manner you have done so. The fifth and final point that I can provide to you is document, document, document. And this is true across all aspects of claim handling, whether litigated or not, but particularly relevant in workers' compensation matters that are litigated. Once a case becomes litigated, actually before it becomes litigated, even if it's accepted claim, I strongly encourage my employers to create a work comp log for that particular injury. Notice of the injury. This is who witnessed it. This is the contact information, the full names. Oftentimes we'll go back to an employer a year after a claim and say, who witnesses? Oh, it was Jose. Well, which Jose? Is the person so, well, I don't know. But if you document it when the claim first began, when we go to litigate that file and we ask for witnesses, we have the full name of that person, and we can, so even if they're not working for you, we can track them down. So document from the beginning. If you have a request for information, how you responded, who responded, so on and so forth. It doesn't have to be extensive. It just has to jog memory and indicate what it was that you did. If you are having trouble enlisting the assistance of a claim professional or legal professional handling the claim for you, enlist the help of your broker. I find broker representatives really valuable. They often have the ear of someone above the claim handler, perhaps in the underwriting department, perhaps in the management of that insurance company, and they can part the waves, so to speak, and assist in the defense of it, and assist in having you involved in the process. The final part of my presentation is 2 resources I want to offer to you, and I strongly suggest you get a copy of the PowerPoint, if nothing else, for these resources. One is the DIR website, and it's posted there on your screen. You can Google it, dir.ca.gov, and you can pull it up under DWC Workers' Compensation. About the middle of the page of the link that I've given you is a caption that says information just for you, and it has a variety of categories of participants in the workers' compensation system, including employers. Take a look at those links. There's a link for injured workers. It has most of the workers' compensation forms that you're going to be involved with as an employer. Excellent, excellent, excellent resource to understand the workers' compensation system and pretty much understand why most defense workers' compensation attorneys are somewhat loopy. There's just a lot there, and it's a lot to keep up with, but there is, as I said, a tab for employers, a tab for injured workers, and you can, and I do encourage you to point your HR folks, your supervisors to this link so they can take a look at the website and understand what they're up against or what the process is all about. The second link that I provided to you is kind of a little sleeper jewel for information, and is what's known as the public EAMS index system. EAMS stands for Adjudication Management System, something along those lines, and it is available to the public. and it will give you basic claim information about a particular individual based on their first name, last name, and their date of birth. The sign-in is relatively easy. You enter your name and an email address and why you're doing it. Generally, you can just say preparation for hearing, and it'll get you in there. I'm not sure if the state takes this, statistics for it or not. I don't know quite what they do with that information, but you can get in there. You can index an individual, and you can find out about prior claims. That's in fact how we found out about a claim that had just been settled for an individual where we were working on a present claim. So it's a very, very valuable resource that I encourage you to take a look and know how to access that information to manage your workers' compensation claims. That's my presentation. I'll welcome any questions at the end. I think the employer involvement in the workers' compensation process from start to end was very, very valuable to me as a defense attorney, and I would encourage employers to take the time to oversee their claims. And now I think it's done.
Thank you so much, Yvette. Next up, Don Dressler is founder and managing partner of CalWorks Safety and HR. Please welcome Don.
Good morning, everybody. Thanks so much, George and Joan and Yvette, because they've been very invaluable partners for working in this area of workers' comp. What I'm going to cover today quickly is experience mods, which have been mentioned briefly, and why you need to control claims, what to do before you have an injury, what to do when an injury occurs, investigating injuries, medical provider networks, which is what we call MPNs, return to work in the interactive process, forms that are important for you, and consider having a safety audit. So this is a fair amount. We're going to go through it quickly because we want to preserve time at the end for questions that you may have. Every employer has an experience mod if they have workers' comp payroll covered or expected losses of approximately $10,000. That number varies a little bit, and I haven't seen the exact number for 2022, but it'll be in that ballpark. So what that says is mostly mid-sized to larger employers and manufacturers and warehousemen and people who are in the maintenance business have this. A small clerical office may not have an experience mod. The rating is shown on what's called an experience rating form, and the insurance company that covers you gets that from the state workers or the Workers' Comp Insurance Rating Bureau, and the insurance company sends this to your agent. So you ever want to see this form, if you have an XMod, ask your insurance agent for it, because they either will have it or they can get it. There's a lot of important information there. Realize of the 2 million businesses in California, only 110,000 are experience rated, but they make up 80% of all the workers' comp insurance in California. What can you do about your XMod? Well, if you know your XMod, and you need to know what it really is. 100 is average, and that means that you're performing the way everybody else in your industry or classification is performing. If you have an XMod of 125 or higher, it automatically classifies you as what's called a high hazard employer. That has a couple of implications. First of all, you have a surtax or surcharge on your policy because of this. And second, you are targeted by a specific unit of the Cal OSHA enforcement branch called the High Hazard Unit to do inspections. So it increases dramatically your chances of an inspection. Also, you would likely during a year get an offer from the Cal OSHA Consultation Service to come in and review what you do. We would encourage employers to do that. But if you're our client, we would be happy to help you, because the consultation service will come in and ask for a lot of information that you may or may not have available. And then after a few weeks, usually give you a notice that says within the next 30 days, you need to do the following things. And if you don't do the following things, we're going to turn this case over to Kalosha Enforcement. So what we're there to do is help you make sure you do all the things that they say you have to do. There are also recommendations that they make that are optional, but it's a good process to go through, but it's also probably needs some help in getting through it. Your experience mod's based on a 3-year period of time every year. There's 1 year deleted and New Year's added. So if you know your XMod from a year ago, that doesn't mean that's going to be your XMod now. That's one of the reasons it's a good idea to ask for your experience rating form so you know what the calculations are. Also on that form, if you get an XMod, there's a number called a primary threshold. That means you're charged with every dollar of every claim up to the threshold. And the threshold could be as low as $5,000 per claim to as high as $70,000 per claim. We have a number of employers who have a threshold of $5,000 to $7,000 or $8,000 per claim. We have one client we're working with now that has a threshold of $49,000 per claim. The reason I say that is every dollar that gets paid out on that claim for medical care, for temporary disability, for permanent disability, counts in your XMod. So you need to know about it and do what you can to control it. They do deduct $250 per claim in that process to account for what we used to call first aid claims. There's also a statement on that form that says loss-free rating. It says if you had no losses, this is what your XMod would be. It's very helpful to know that and to use that as a target for running your business. There's some things you should do before somebody gets injured. So don't hire an injury. Use the hiring process and the evaluation process. You can use things what we call a post-offer pre-employment drug and alcohol testing, background checks, even fitness for duty exams, meaning the physical ability of the patient. Those depend on the nature of your operation and so on. But it's very good to know about the people that you're hiring. I realize today there's so many job openings, people are having trouble hiring. The problem is you may have an easy time hiring a problem, and so you'd want to know about that. The second thing is you have an obligation under Kalosha to train people on the work exposure for their safety before they start work. And the best way to do that is in your new hire orientation process, have some plan for some safety training, and we can help you with that. But even if it's very basic things that are your safety processes and rules, it's important that you do that. You need a written safety plan, so-called illness injury prevention plan. It's been a California requirement for 40 years if you have even one employee. It is still the most common Kalosha citation. So don't take it for granted. And I would also suggest that the Kalosha Enforcement Agency is changing its focus from time to time on what parts of an illness injury prevention plan they look at. In the current time, they're looking particularly, for example, on the provisions and training for supervisors and what their responsibilities for providing a safe workplace are. So it probably makes sense every few years to have somebody review your IIPP and make sure it's current. You need to know what to do if an employee is injured, and whoever is going to be talking to the worker, whether it's a foreman or a supervisor or HR person, somebody needs to know what to do, because when you have an injured person on your hands, that's a hard time to start figuring out, now what do I do? So you'd know what questions you're going to ask, what steps you're going to take, what medical facilities you're going to use. And with regard to medical facilities, we suggest that you use a medical provider network, which is a specific set of doctors that are listed and approved by your insurance company. Because if you offer medical care through a MPN, you have life of case medical control. If you don't, you have control for the first 30 days, and then the injured worker's attorney has control. And believe me, the doctors the injured workers attorney use are not going to be particularly helpful to you. When an injury occurs, first of all, obviously you deal with any medical emergency or required first aid. Bleeding and breathing and broken bones and things need to be attended to right away. As quickly as you can, you need to talk to the injured worker and ask what happened. This is a step we often take for granted or shortcut, and this can be one of the most important times in the whole handling of the injury. If you can, take them to where the accident occurred and have them explain or reenact it. Sometimes you're hearing about an injury days after it supposedly occurred. Sometimes you're hearing about an injury that nobody witnessed. The problem claims seem to come up to those kind of categories: late reported claims, unwitnessed claims, and so on. You can deal with that by asking questions and taking care to do some investigation right then. If medical care is needed, you want to either refer them to your workers' comp medical provider. It should be posted on your employment posters on your wall. Hopefully you're using an MPN, medical provider network, authorized by the workers' comp insurer. If at all possible, we suggest you take the worker to that facility, even if they can drive. And the reason for that is you make sure they go to the right place. Also, you're there, so you know what happened and you know whether the doctor has any work restrictions. You're there to talk to the doctor after the medical evaluation if needed. It's important to tell the doctor if you have any thoughts or concerns. Ask them what the work restrictions are. And then you can arrange to take the worker home or to their car or whatever. How you treat the worker and their morale and their attitude emotionally is an important part of controlling claims costs. Every accident needs to be investigated. It's a requirement of Cal OSHA. It's a requirement of your written safety plan, and it's a requirement for your workers' comp policy. If you need help, call for help to do that. It's good to train your supervisors in advance how to investigate accidents, near misses, and so on, because they can be right there and can start the process as soon as it's heard. An accident investigation needs to take place. You can secure the scene, find out if there are witnesses that are available. We will strongly recommend photographing the scene and the injured worker, because sometimes a left arm becomes a right arm, becomes a bad back, and we'd like to know what was injured when we started. And think about what you need to do as a basis of your investigation. After the injury, one of the things you need to do when a worker tells you as a work injury is give them a workers' comp claim form. We call it DWC-1 claim form. Employees are very problematical in what information they give on that form, how much they complete it. The easiest thing to do is when they give you the claim form back, you'd ask them details and fill in the missing blanks and ask what happened. Because you've got it right there. Before you send it to your insurance company, before it's down the road, you have a chance to get the correct information and thorough information right then. Now, if the first time you hear about an injury is from an attorney and they already have filled out their own version of a DWC-1, that doesn't mean that you don't get to conduct an accident investigation, but it means you're behind the curve. As soon as possible, and we would suggest same day, next day, but certainly within 7 days, you have to send the DWC-1 and a form you prepare called the employer's first report of injury to your workers' comp insurer. The sooner you do that, the quicker the insurance company is able to set up their records and start to manage any problems that may come out of the claim. Also, if you fill out the employer's first report of injury and actually read it, the things that you need to know from an accident investigation are right there. And you can know that within the first day or first week of an injury. Coming back later, weeks, months later, very hard to figure out exactly what happened, what tools the person was using, how it occurred. It's easier and much better to do it and should be done right at the beginning. Unless the worker is hospitalized, we suggest you have a return to work policy. It says the worker come back to work tomorrow. Maybe come back to work under work restrictions if the doctor advises it, but you need to see and have a connection with the injured worker. Somebody at the company would be helpful if they call them that night and ask how they're doing, if they're doing okay, because the employees who feel that their employer cares about them and is interested in them are much less likely to litigate a claim. When they come back to work, greet them and say, "We're so glad to have you here." If a follow-up medical exam is needed, and it often will be, ask the employee to bring back the medical report or work restrictions. Don't wait for the doctor to send it to you. Don't let them come back to work without the form. They can drive back to the doctor's office and get a work restriction right then. That way you know and are in compliance with any restrictions that the doctor advises. Plus you know that they actually went to the doctor, because that becomes an issue sometimes. If a worker tells you they're in pain, they can't do the work, don't just commiserate with them. Say, go back and talk to your doctor. Make sure your doctor knows that. Make sure that they're aware of it. We've had cases where a person comes and says, well, the doctor told me X, Y, and Z. And the doctor didn't do any such thing. It's important to have the documentation from the treating medical professional. If a worker is out of work for a while, keep in contact with them. Don't let them sit out there wondering what's happening or whether they care. The medical provider network, I've already said that, gives you life of claim medical control, and medical control are the determination of many legal issues in a workers' comp claim. Is it work related or not? Does the person have a permanent disability or not? Have they reached what we call a stationary condition where they don't need medical treatment or not? What work restrictions they have? A lot of things come out of what the decisions that treating physician makes. If the person goes outside of the network to their own doctor or a doctor from the attorney, then there are restrictions on how that information is used. Chiropractors are only permitted to do certain types of medical provider work. The best course is to take your worker to your medical provider. Let's take for a second about the value of return to work. This is less of a problem than it was years ago, but it still is a concern. Realize if a worker comes back to work for you, the day of injury, you pay them for the day of the injury. If they come back tomorrow, they're on pay. They get paid and they're going. If they're on a temporary disability claim, they only get about 2/3 of their pay. So it's the employee's benefit to be back at work. It's to your benefit to be back at work, because in the workers' comp XMod process, any money that gets paid for temporary disability is multiplied by 2 or more times in what's charged against you for your future experience and your future experience mod. It saves you potentially $6,000 on a particular benefit, a supplemental benefit under permanent disability cases. It gives you the value of reducing the person's lost earnings and also keep them competent and concurrent with work. It's much more important to have an experienced worker on the job than trying to cope with what happens when somebody else has to fill in on their duties. There's a particular twist in California in that sometimes people think if it's a workers' comp claim, that's all I have to worry about is the workers' comp process. But a workers' comp injury is also a disability under California's Fair Employment Housing Act and the Americans with Disability Act. So if a person's experiencing limitations on their ability to perform the essential functions of their job, you need to talk to them about it. It's called the interactive process. And failure to do so can cost you up to $20,000 in fines or in litigation. So it's a good thing to do, and it's a legally important thing to do, and it has to happen for non-work comp claims as well as work comp claims. But it's important that you don't think, well, that's workers' comp, I don't have to worry about it. The other part I just want to share is kind of following on what Yvette said. Not every reported injury is a workers' comp claim. If you ask questions about what happened, when an employee starts at the very beginning to tell you they have injuries, feel pain, have been made sick on the job, you want to know what I call the 5 W's. When it happened, where it happened, how it happened, why it happened, who saw it happen. Are they really injured? Number one, did it really happen at work? There's some legal terms like arising out of and in the course of employment, but it all gets down to knowing what really happened. And so also OSHA requires you to do this. There are some red flags. If a claim is reported late, and the later, the bigger the red flag. If it's reported the first day of a work week, especially if it's first thing that week, how did they just get hurt that fast? Didn't they have maybe this injury from over the weekend? If there's no witnesses, that's a concern. If you have a employee who has a history of discipline, they have a way of using the workers' comp system to fight back about the discipline they have. So you need to be aware of that. If somebody asked for time off and wasn't given time off, they may say, well, I'll have a work injury, so I get the time off I wanted. If there are other people in their family that are ill or have had workers' comp claims, this doesn't mean that the claim's not valid and that they aren't really hurt, but you need to kind of be aware of that. So those are just red flags of claims. How we can help at CalWorks Safety. We can help conduct an HR audit of your operations. We can keep your update of handbooks. And let me tell you, there are about 20 new laws that take effect between now and January 1st, 2022 that you need to look at. They're not, most of them are not severe unless you're in certain particular industries like warehouses, restaurants, and facilities have some significant new rules. But you need to know what the rules are. You need to conduct a hazard inspection and make sure you have an effective written illness injury prevention plan. And there are other host of OSHA requirements that may apply to your business. If you have problems with employees and you'd like some help with interviewing them to determine what's going on or conflicts, we can help with that. We can also provide training for safety and for sexual harassment training. Remember, the sexual harassment training has to be provided every 2 years. And there's a 1 hour every 2 years for all employees and a second hour for supervisors. We are beginning a new process and we're rolling out to make available to our clients, and that is a safety audit. Now, the safety audit for us looks at all of the issues involved, including the workers' comp losses and claims, your OSHA 300 logs and reports, as well as their operations and injuries and workers' comp history, to find out how is your operation safe and can we see some overall suggestions. Realize that Cal OSHA fines and federal OSHA fines are dramatically going up in 2022. When Congress passed the Budget Reconciliation Act a few weeks ago, you may not have noticed, but they funded the federal government out of fines on employers out of OSHA. And California has to adopt an equivalent rule according to the federal rule. And so we're expecting to see likely Cal OSHA fines doubling or more starting with January 22, and you'd like to set yourself up to avoid it. Also, there's some new classifications, we'll talk more about this next month, with employers that are egregious violators or have a lot of enterprise facilities, so-called enterprise violations, which the safety audit can help you with. We're here to help you with HR and employment and workers' comp law. I hope this has been somewhat helpful, and we still have time for some questions.
Perfect. So we just have one question so far. If anyone else has any questions, go ahead and put it in the chat box. So the first question is for Joan and George. We are now paying our workers' comp per payroll, as we are told that there will no longer be a possibility of short pay or overpay at the end of the year. What is your opinion of this option?
Yeah, I think it's a great option because you what in effect you're doing is you're able to more or less pay as you go as far as your payroll. So, you know, assuming you've got you're doing it correctly and you're doing everything in the right category, there will still be a final audit, but it should come out to be pretty much exactly what it's supposed to be based on how you've reported your payroll. And we've got several clients that also do that, and they seem to like it.
Yes.
We have other clients who don't like it because it does require a little bit more administration on their part. And they're wanting to spend that time on other tasks, and they don't want to be bothered with it. So it varies by client. And for example, contractors who have a payroll that varies, whether it might get really busy one month and then be slow on another month, that works really well for them. So again, it's a great option. I like it.
All right. Do we have any more questions?
Jake, if I could just say that I hope that you would put on your calendar November 18th, the Thursday before Thanksgiving. That will be our Zoom webinar for the month of November. We try to do one of these programs the third Thursday of every month. Next month, we will have a presentation on the new laws that are effective for 2022. They range all the way from leaves of absence to dealing with COVID, to new rules regarding Cal OSHA, rules regarding independent contractors. So we will do a recap of that, and we'll also have a handout analyzing those new laws available after that workshop. So put November 18th on your calendar for our next event.
Great. Well, thank you everyone for sharing. This is an important topic. And remember, if we didn't address your questions today, go ahead and reach out to us at info@calworksafetyhr.com. Or no, actually, is that
Yeah, that's it.
info@calworksafetyhr.com. Thank you everyone for attending. Have a great rest of your day, and hopefully we'll see you next month.
Thank you.